We can distinguish between two main domains of relevance of neuroscience for criminal law and criminal cases. The first domain is theoretical, and it concerns the application of brain-based knowledge to criminal law doctrines and theories that are mostly concerned with criminal responsibility, while the second domain includes a procedural use of neuroscience, whereby neuroscience is introduced as evidence in court proceedings. When it comes to the theoretical level, as I mentioned, neuroscientific theories and data are generally used to call into questions normative assumptions about human behavior that underpin theories and doctrines of criminal responsibility. And neuroscientific studies, modern neuroscientific studies, are suggesting that emotions are critical components of our rational decision-making, especially in moral and social context. And when it comes to the procedural level, neuroscience has been introduced in court proceedings as either individualized evidence to support the claim that a specific brain condition determines the individual's behavior, and it has also been introduced as framework evidence, so as a general evidence to support claims concerning broad or entire categories of individuals. And a paradigmatic example comes with the punishment of children in the United States, where neurodevelopmental theory was critical to support the Supreme Court's conclusion that the application of extreme punishment, such as death penalty or life imprisonment without the possibility of parole, was too excessive for children, considering that their brain's immaturity and their consequential diminished culpability. I can think of two insights that are particularly intriguing or even challenging for the criminal law. The first insight is that the brain is plastic, so brain plasticity. So the brain can change in response to changing environments and experiences, with implications on the behavioral level. And the second intriguing insight concerns the long-term adverse neurobiological effects of socio-environmental deprivation with negative consequences for psychological well-being and prosocial behavior. So both insights seem to call into serious questions mainstream ideologies of punishment, but also and especially practical applications of punishment, including incarceration and its methods. The most emblematic example in this case comes with solitary confinement. So there is an increasing use of neuroscientific evidence in Eighth Amendment cases in the United States to support the claim that solitary confinement, especially long-term solitary confinement, implies neurobiological damages, most of which can entail irreversible consequences. And this body of knowledge is being critical to support the claim that solitary confinement is a cruel and unusual punishment under the Constitution. I can summarize the perils of bad uses of neuroscience in criminal law with a famous expression coined by quite a famous criminal law scholar, Stephen Morse, which is the brain over claim syndrome. This syndrome consists of inferring a direct causal relationship between the brain and the behavior. So over assuming that what the brain does causes human actions. This is entirely misleading because we don't know yet how the brain enables the mind and how it is linked to human behavior. So the peril of the brain over claim syndrome is that it creates a misleading narrative of criminal conduct, the one that goes back to Lombroso or to phrenology, and it can also ground bad uses of neuroscience in courtrooms. I think that neuroscience has certainly the potential to shift paradigm of justice from exclusion, social deprivation, and punitiveness to approaches that are more grounded in social rehabilitation, inclusion, empowerment, and reacceptance. There is a sustained body of research that is trying to use neuroscientific knowledge about the impact, the positive impact of social engagements and social connections and emotions to lend support to the tenets of restorative justice, which is an alternative restorative justice approach that aims for reconciliation, reparation, empowerment, and reacceptance. So the restorative justice espouses a view of the individual as someone with a dynamic moral character, which means that people can change, but change cannot happen without the necessary social support. So neuroscientific knowledge about the importance of healthy social environments and social relationships is definitely bringing a huge empirical support to the tenets of restorative justice, and therefore it can support a greater use of restorative justice within the criminal justice context, which is a hot topic right now, not only in Europe, but also in the United States.